that acceptance or that recognition that appeal is not before you, the fight about that appeal is not before you, dispenses with the third respondent's contentions about preemption, for example. We should not even have to canvass that, because we are not here seeking a review of the Commission's decision on appeal. Never mind that the facts are not pleaded for preemption. There are those problems with it, but it's not an issue that you have to decide. It doesn't enter this equation. Similarly, the first and second respondents raising Electoral, they raise it, they're entitled to raise it only if we were here about the dismissal of that appeal, about the decision of the Commission to appeal that decision. Then they would say, in fact, we even have a ready answer for that. They would raise it and we would say, but that's exactly why we are here. If we were here about that appeal, we would say, that's exactly why we are in this court. It is because Electoral says that decision stands until it is set aside by court. But it doesn't enter the picture because we are not here about that appeal. All that is said in the papers about the appeal is, and the decision of the Commission is irrelevant for purposes of consideration, of determination of why we are here before you, of our application. Now, the facts, in fact, perhaps let me start with what our case is. We say to you, we say that the application before you is about two things that we have pleaded. It is the exercise of the power to approve the registration of the third respondent after the Deputy Chief Executive Officer had made the decision to reject that application. That's the first issue. The second issue that we have pleaded as a complaint for determination is about a defective Section 15.4a notice, where we say it doesn't comply. We don't persist with that leg of the argument, so you will not hear any submissions from us on that. In our case, we set it out in the founding affidavit at paragraphs, and I'll just mention them for noting because of the constraints of time. We set out at paragraph 11 and 12 of the founding affidavit what it is that brings us here. And then in paragraphs 19, 22, 68, 70, 71, 72, 75, 76, and 77, we set out the facts, the complaints that we are raising, and why we say the decision that the registration is liable to be set aside. It is in those paragraphs. And at paragraph 20, we say there was no new application before the Deputy Chief Executive Officer to decide. And then at paragraph 20, we say insofar as he gave the opportunity to supplement that application that has been rejected, he acted ultra vires his powers. Now, the facts, the relevant facts are largely common cause. And it is this. It is on the 4th of August, the application for registration is rejected. And it is rejected, and there's an invitation, an unnecessary invitation, but a helpful invitation, because the IC has to be helpful to applicants for registration. That says nothing precludes you putting in a new application. We say that was unnecessary to say, but in the discharge of a public function to be of assistance to members of the public, they state that. And that's all that it is. That in itself, that kind of invitation or assistance, we don't complain about it, that they told them what to do. Now, it is also common cause that there was no new application. On the IEC's case, and on the third respondent's case, no new application was submitted. I must say, my lady, that in fact, in the answering affidavit, the third respondent initially prevaricates about it. They are firmer in the heads of argument. But in the answering affidavit, they speak of it as whether it's a new application or a supplemented application. They quite noticeably do not commit to what it is that was before, certainly not in the answering affidavit. But they do in the heads of argument. They say, well, we supplemented. So we know there was no new application. We know we know from the IEC that it considered a supplemented application, not a new application. And the supplementation, which is the word that they use, the supplementation is the replacement of signatures that according to the letter of 4 August appear to be fraudulent signatures. And the supplementation that we are told about is they put in a new list of signatures. So that is the supplementing. We say, so before you, what you're required to decide then is whether that so what we do know, perhaps let me finish off the matrix of common cause facts, is that then on the 7th of September, the DCO makes a new decision, and that new decision is now to register, and it is made on the basis of a supplemented application. So the question before you is, the first question would be, was the decision of the DCO to reopen that file, and will make submissions to you that once he's rejected the application, that application is defunct. That file is done and it's closed. And we will show that on the Commission's own papers, they understand the difference between a live application and an application that has been rejected. They understand that. So what they do is, so the first question is the decision of the DCO to consider a rejected application, allow it to be supplemented, and then make a decision on the basis of that application. We say it's not permissible because the decision to reject that application was a final decision. And it is a final decision, but by its nature, however one constructs and interprets the letter of 4 August, it is clear by dictionary meaning, it is clear by context, it is clear by the reasons given for rejection of that application, that it is a final decision to reject an application. But if there was a doubt, it is clear in the advice that is contained in that letter that put in a new application, that the DCO considered himself to have dealt finally with that application.
Ms. Baloyi, I'm told by the way your client responds to the Commission's version about its intention when it sent the 4th August letter. And perhaps you should look at these paragraphs so that you can assist me. I'm saying I'm troubled by the manner in which your client responds to the Commission's version regarding its intention when it sent the 4th August letter. And I think it would assist if you go to these paragraphs so that you can, if you look at paragraph 5 of the 45, of the Commission's answering affidavit.
The Commission's affidavit?
Answering affidavit, yeah. It says in sending the 4th August letter.
I do apologize.
Paragraph 45. Let me wait for you to get there.
Yes.
Are you there?
Yes, I am.
Yeah, it says in sending the 4th August letter, the DCEO did not intend to foreclose the possibility of Umkhonto Wesizwe submitting a supplemented application, right? And your response appears on page 210 of the bundle. It's paragraph 65 of the reply. And there's an admission there that the door was not closed on the MK part to supplement. You see, the allegation you are responding to is that the door was not closed to supplement. And then there's an admission that indeed there's an admission that the door was not closed to supplement.
Yes.
But then you go on and your client says, however, I deny that the commission invited them to submit a supplement.
My lady, what is contained there, it's two things. Founding affidavit. We do make the point that once the application was rejected, the door was not closed for them to bring in a new application. We say, and as a matter of law, they could have submitted a new application. Yes. And that's what the letter of 4 August was conveying to them, bringing a new application. So where we say that we admit that the door was not closed to them, it is simply to that.
But the paragraph under that you are responding to,
yes,
it relates to the intention not to preclude them from submitting a supplemented, not a fresh application, yes, a supplemented application. And your client's reply there is an admission that the door was not closed.
Yes. My lady, it depends. One cannot read the replying affidavit divorced from the founding affidavit. In the founding affidavit, our position is unequivocal. And that's where we make the case. That's where we make the case, not in the replying affidavit. We make the case in the founding affidavit and unequivocally say that the door was not closed to them. They could bring in a new application. We say no more than that. Now, here perhaps it's inelegant drafting, but this paragraph that your ladyship is referring to in the replying affidavit has to be considered with what we say in the founding affidavit. And in the founding affidavit, where we make our case, we say they could have brought in an application. But further on, in that same paragraph 65 that your ladyship is referring to, if we are in any way not clear because we drafted in the way we did, are disputing an invitation to supplement. So that's what the next sentence communicates. It says, well, there was not even an invitation to supplement. Yes, if the commission had said supplement in its letter, what your ladyship I would expect, what your ladyship would see in that paragraph 65 would be quite clear. That should clear any uncertainty in what we intended to convey in the replying affidavit.
Perhaps before you move on, I've got another question for you. I should raise it now. There's a point your client takes about the lack of a distinguishing mark in the third respondent's application.
The lack of?
A distinguishing mark,
yes,
in the third respondent's application that was submitted to the commission. The application appears at page 111 and 112 of the bundle. It appears to be a copy. So I just want to clarify, perhaps this question I should leave to the commission and the third respondent. Perhaps I should clarify if you are persisting with that point. Are you persisting?
About the absence of a distinguishing mark?
Yeah, in the application.
No.
You are not persisting with that point?
No, my lady, it falls under the complaint about the notice that the Section 45 notice was non-compliant. We have abandoned that complaint. My lady, so I was at a point where I was saying we look, what the court would have to consider is the decision that was made to register, and then to the nature of the decision of the 4th of August, because the respondents say that's an invitation to supplement. It's not a final decision. So the court has to consider that letter. We have the tools of interpretation apart from the terms of the letter itself. And our submission is the letter unequivocally communicates a rejection and an invitation to reopen the application, to put in a new application. But in fact, I said earlier, Malady, I made the submission that the commission and the CEO, they know the difference. And in their answering affidavits, they know the difference between keeping an application open to allow it to be supplemented and making a decision that rejects an application. The differences, that there is a difference. Before you reject, at least that's what they have done in the past. Before they reject, they have given a party the opportunity to supplement. And in fact, what they did in that case, Malady, I just need to find the reference. This is a decision. Yes, this is a decision in an email. If your Lordship would go to page if the court would go to page 121 of the bundle, this is the commission's answering affidavit. And this is from Mushwana Akani, and it is to Mr. Jabulani Khumalo. And this is sent on the 22nd of June, 2023. It says, your application for registration of a political party refers. Please note that the registration is done in accordance with Section 15 of the Electoral Act and as prescribed. Kindly note that in order to meet the requirements, your party must comply, and it is listed, submit a deed of foundation, and then Annexure 2 must reflect only one logo of the party. And the next paragraph is important. It says, we request that you respond by no later than 14 days of this correspondence by sending additional list of supporters required. Please note that your application will not be processed until we have received all outstanding documentation from yourselves. Failure to comply, we haven't finalized it. It's still live. There are problems with it. Fix those problems. And he prescribes a period. Sensibly, one would say, there has to be prescripts. You have to do it within a period. And that's what they do in this letter. They say, you have 14 days to comply. If you do not comply within 14 days, we will reject your application. This is what they do on the 22nd of June. The letter of the 4th of August is completely different. It says your application has been rejected. And what that points to is the commission is alert to what is possible to do before you reject an application. And that which they do here is to keep the application live. And they say so in so many words. They say, we will hold it, we will not process it until you have submitted, and if you don't submit, we will reject the application. So the new explanation that, well, this letter of rejection, forget what dictionary meaning of rejection is, forget the context of the letter, in fact, including this history, because this is to the same party. So the history is relevant, the history of how they have dealt with this previously, this same application. They've told them, if you don't do this, we will reject your application. And they proceeded to do that.
Is that similar to giving them an opportunity to supplement?
In this letter, indeed so. We say, in this letter they say, we don't have I must say, Judge Chongo, we don't have the full history of this and what is behind it and what was submitted.
Yes, but the content of what you are reading now, they're giving them an opportunity to supplement.
Indeed so.
So the CEO or DCO has some kind of discretion.
Well, Judge Chongo, you would have seen that we say there is no such discretion, but that suggests that in him writing in this way, suggests that he considers himself to have a discretion to do this. Well, we make the firm submission that any exercise of discretion has to be grounded in the Act itself.
Well, the Act does not, in any case, say that an application cannot be supplemented.
The Act doesn't say that, but the Act is silent, but he is a creature of statute. And what the Act has done is to define his powers. And the power, any discretion that he has to be found in an interpretation of the enabling provisions that, in fact, it's a reasonable interpretation that it includes that he has a discretion to allow supplementing applications. But what we say is, well, even if he does, even if we are wrong in our assertion that because the Act doesn't prescribe that he's got a discretion to permit supplementing of applications, even if we are wrong with that, the decision of 4 August remains an unlawful decision because that's not an invitation to supplement. He's made a final decision. He is functus officio with that decision, but effectively what he has done with the reconsideration of the same application is he has gone and revised his earlier decision, because that is the legal consequence of what he's done, especially because he bases his decision on the very application that was rejected. So what he's done is, I think an example would be, maybe practically what would happen is when an application is rejected in the public sector, is it would be marked rejected. That's one picture that one has in mind. It would be marked rejected and it would be filed away. Even if it's not marked rejected, it would be filed away because it's done, it's finished. There's nothing more to do with that application. Now, to get to a point where he reconsidered that application on the basis that it is supplemented, he has to retrieve that rejected application. He has to retrieve it and then reconsider. So effectively, he sits in a position where he reviews his own decision and reverses it, because that's effectively what he has done. So we say he's not authorized by the Act to do that. That decision was done, that application became defunct. There was no application before him for further consideration. An application would come before him if a new application was filed, as he advised the third respondent to do.
4 August, could you please take me through the last paragraph, first and second respondents answering affidavit?
Professor, you say I should look at the last paragraph.
The last paragraph.
Yes. It's page 44. Mine is 44. Yes. Yes, we attached it as FA4. Yes, that's what I was looking at page 44. Yes, the last paragraph,
Yes.
Professor says, the application, therefore, does not substantially comply with the provisions of Section 16 of the Electoral Commission Act and regulations. And then there's a signature.
I'm more
This
interested
rejection of the application does not debar you from submitting a fresh application.
Yes, I want you to pause there. What does that afresh mean? Doesn't mean you can supplement what you have already submitted, but address the shortfalls that have been identified?
Yes.
Or does it entail completely coming up with a fresh application?
Professor, not to be facetious, I must say that I'm actually even embarrassed to pull it from my file. The dictionary meaning of Oxford Dictionary, supplement. You can't be supplementing if it is a new application, because what the third respondent, assuming that the third respondent considered, and it must have, because this letter speaks for itself, that the third respondent considered itself to be submitting a new application when they supplement. The debate would be, well, let's look at it. What did you do with it? Right? What did you do? But we know that the letter says, just complete the signatures. Give us that signatures. So there is no new application by any definition. In fact, the third respondent doesn't assert that it submitted a new application. It doesn't. It makes common cause with the IEC that it's supplemented. And we say, but the decision maker said to you putting a new application. Now, what this decision maker then goes on, new application from you, and later on makes, when there's now supplementation, they tell us in their papers, makes a decision, well, that decision that I made is now set aside, because that's really what he did. It's now set aside. I will now consider this old application as supplemented.
Yeah.
And there's no other way of coloring it.
Let us roll the wheels back just a bit. The 1st of June 2020. When an application was made and there was an opportunity to make objections. 9 June again, opportunity to make objections, and nothing occurred. What would have had happened there had the objections been made?
At which point, Professor?
Between 1 June, the first period being the 1st of June 2023, on the first application, wherein the commission, the deputy chief electoral officer identified some concerns regarding the logos.
Yes.
And your client there had never made any objections.
Yes.
The second period, that is the 9th of June, again, no objection whatsoever forthcoming up until you come back now to the rejection afresh.
Yes. Well, Professor, what we say is that we did not object in the first and second notices. Is of no consequence. That is before you. It is of no consequence whatsoever. It would be of consequence if there had been a new application, as this letter says,